Hello, and welcome to the Legal Environment for HR. My name's Adele Abrams, and I'm going to be your instructor this semester. We're going to be covering a lot of material. It will not be covered in the depth of a law school class, but we will be covering 7 statutes plus in 7 weeks, so brace yourself for that. However, I think you're going to find this to be a very interesting and useful course. While the goal here is to make sure as you enter management in the business environment that you're able to keep your company out of trouble, I also want you to be looking at this through the prism of understanding your own rights as a worker, because not all of us are going to be company presidents. I'm a practicing attorney myself. I am with the firm Littler Mendelson out of the Washington, D.C. office, and I headed my own firm for about 25 years. I've been teaching this course for quite a while, and I have to say, we are living in some interesting times. I'm not going to get on a soapbox here, but I do want to alert you to the fact that employment law and the EEOC policy in particular is changing at warp speed. And there are a number of things in your book that currently are not technically accurate. Legally, in the light of case law precedent, they are accurate. In the light of this administration's executive orders, some of the information is not accurate. And so during the course of this course, I'm going to be trying to post for you in the announcements section generally things that I'm flagging for your attention. For example, right before this course is starting this semester, the Trump administration just announced that they had killed the Biden administration independent contractor rule. They're going to be republishing it, probably going back to the original Trump 1.0 version. They've similarly just changed the definition of joint employers. And some of these are concepts you're actually going to be covering in week 1 of this course. So we're going to be teaching to the book for purposes of exams. But I do invite you to, be cognizant of what is going on around you in terms of your research paper project. Yes, there is a research paper. Yes, you can pick your own topic. I do have a number of suggested topics in the discussion board for you to take a look at. And so it's up to you if you want to use one of those topics or something else. But I'm okay with addressing a changing topic as long as you're doing it as a legal research paper and not just an opinion piece. Similarly, we're seeing reverse discrimination actions now being fostered by white applicants against employers. That's something new out of the EEOC. Had they done it before? Sure, but not for many years. We're seeing changes coming for sure on things like religious discrimination, English-only rules, a lot of concepts we're going to be covering here. And President Trump even put out an executive order saying that for the federal government, they're not going to be recognizing disparate impact discrimination cases. And I have to tell you, that's one of the linchpins of civil rights law in the United States. It's still a viable cause of action for private sector employers, but not at the federal level for public sector currently. That could change again. There's a lot, as Bob Dylan says, the times they are changing. And so that's a song we're going to be humming quite a bit, I hear, during this semester. But I don't want you to be worried that you're going to have to be ripping from the headlines every day in order to pass this course, because the fundamental precepts of employment law are remaining the same. And we're going to be getting into some other things. Constitutional law, again, some of that is changing, and the agencies no longer get what's called Chevron deference, for example, where if a regulation is ambiguous, they would defer to the agency's interpretation as long as it was reasonable. That went out the window with the Supreme Court decision in 2024 in the Loper-Bright case. And now the judge in any case gets to substitute their opinion for the subject matter experts at the agency. These pendulums tend to swing back and forth. We may see more changes coming from the Supreme Court during the course of this semester even. But again, I want you to enjoy this course. The first week looks like it's really going to be a kneecapper, and it is to a certain extent in terms of the reading burden. There are 4 chapters, But please stick with me. Don't drop the course, because after that, you'll be reading a couple of chapters a week. We're not going to be overloading like that. The first chapter is pretty much an overview of employment law, labor law, and then we're going to get into things like contracts. We're going to get into things like the independent contractor issues, employee privacy and surveillance issues, and libel, slander, a whole lot more. It's pretty interesting stuff. So I think the 4 chapters that you have to read in the first week will go pretty quickly. And then we're going to get down to the statutory analysis. And so remember also, we do have spring break that will be interrupting, and during the spring break week, we will not have any assignments due. So make sure to check your calendar, because I will be noting the due dates of assignments in there as well. If you have any questions, you can reach out to me. My own personal email is usually the quickest way to get a response, and that is safetylawyer@gmail.com. So you might want to put that one, with an asterisk on it or something. And I wish you all of the success. Again, part of this course is to teach you how to be responsible managers. The other part of it is to understand that you have rights. So it's the responsibilities part and also the protected behavior, the protected rights. So I wish you a lot of luck with this. Again, I look forward to working with you and getting to know each of you during the course of the semester. Take care. Have a great year.